Right, hello everybody. We should be live now. This is episode 2 of my live stream, which is a lot more amateur and accident prone, I think, than Mike's. Oh, and I'll just there's the first accident. I'll just mute my video. So there we go. Well, I'll just mute that like that. Right. So I've got today we've got Shannon and Karis and Mike with me, and I'm afraid that, and this will get better over time, I hope, that we will come up with more of an agenda. We haven't got the luxury that we have on Mike's channel of sort of a lot of comments, and I suspect we probably only get one or two, and they may just be from us. So if I go back to comments, I can just check I can see them, and then we can. Oh yes, hello Cheeseface. I can see you there. I think what's happened, Mike, is that the comments that you left, once I went live, they've disappeared again because they're not
Do you want me to
showing.
stick it up again?
Yes, please.
Cool. On a sec. So this is a question I got in through. Hold on, man. Okay, I see. Oh, that's clever. So this technology is new to me. So I don't know if that's going to work. It's saying it's going into the live stream.
Oh, yeah, I got you. Okay, so here we go.
Well, should I give a bit of explanation on where this came from? Because
yeah, I mean,
yeah,
I didn't give you a chance to say hello. And if there's anything else you'd like to say before you dive into the comments, please feel free. But this is your comment.
yeah, well, I've got so I was just saying to you about Shannon's just done a podcast with Homeless Link, so I'm going to put the link into the live stream. It's about half an hour long, and I don't want to say too much because I'm going to get myself in trouble. But basically, it's really good. But basically, this might be the first time, certainly I've ever seen Homeless Link talking about gatekeeping. Now they're not actually using the word gatekeeping in their kind of blurb as far as I can tell, but they do talk about it. So there's basically Shannon and a friend of mine called Mandy, who's basically a very experienced housing officer, talking about just their experiences of gatekeeping and kind of just talking about some solutions to it. So it's worth checking out. Basically, I think, as I say, I might even I'll probably keep plugging it a bit and other things as well because it's worth listening to. So check it out.
Excellent, I'll do that. And how are you doing, Karis?
Yep, really good. I don't have that exciting news.
Okay. What I will do is I'll go back to Mike's comment. I think I've set it so that it automatically disappears after 30 seconds or something, but I can bring it back if we need to. So, Mike, do you want to talk us through your comment here? And hello, Dan.
Yeah, it's just.
Sorry.
Yeah, Dan's as well. Yeah, it came in on the Facebook group, so I thought it's just an interesting one because it's not actually something I remember answering before, so it's kind of a new question, but it's a good one. So you read on the screen there. What happens to banding when Section 21 expires? Does it move up automatically, or does it stay the same? It's just gone. Or does it stay the same as the banding you've already been given? So we've talked quite a lot about Section 21s before, and at what point you become homeless. And effectively, in most cases, you are legally homeless when the Section 21 expires. It's not when the possession order is granted. It's not when the bailiff comes knocking. It is when the Section 21 expires. So check out previous kind of live streams about that sort of thing to get more detail. But this is an interesting question because when you make a homeless application, one of the things that enables you to do is to join the housing register. But whilst you're in that prevention duty stage, which is the duty when you're threatened with homelessness or when you're likely to become homeless in 56 days, or when you're in the relief duty, which is kind of after making a homeless application when you're homeless through to making the decision, which should again be 56 days. Generally speaking, and this is a generalisation, most councils will they have to give you a banding, and often councils will give you the lowest banding possible, but not all of them do. So Bedford actually gives you band C when you're in prevention and relief stage, and then you go up to band B when you get the main duty accepted. So in this question, in one sense, I would expect most policies that nothing would change when you go from being threatened with homelessness through to being actually homeless. So when you move from prevention duty to relief duty. However, it's still worth pursuing because once the someone's be back in. So once the relief duty has been accepted, the time starts ticking. And if councils are going to tell you that you're not homeless until the bailiff comes knocking, then actually that's potentially many months that you're not in the correct banding. So for someone in this situation, what you want to do is when you're in prevention duty, when the valid section 21 is served, and it's within 56 days of it expiring. And then when it goes to actually expire, you want to make sure the council is accepting you as homeless, because it might make an immediate difference. You'll still be the same band, but then the 56-day time limit starts ticking on the actual relief duty. So then they have to make a final decision much sooner. And this can actually be the difference of many months between between actually kind of joining the housing register, getting the right banding, and being housed. So it's just worth kind of pursuing. Does that make sense what I just said? Because it's as I say, it's kind of, it builds on what we've talked about before. But it's kind of an interesting thing how the process develops, and just the importance of getting the relief duty started when it should start, because that could, as I say, could be a difference of maybe 4 or 6 months to actually how long it takes to get housed. So yeah, that's kind of my little bit there. I see Dan's got some questions in there, but yeah, as I say, does that make sense what I just said? Was that a coherent answer?
It does. Although the one thing I would say is always it depends on the allocation scheme, and some allocation schemes. When I saw this, I was thinking I sort of, does it move up automatically? But I didn't register that, and I was thinking sometimes you can actually be worse off if you're homeless, because you then get treated as being in the homeless queue or whatever, and you lose out. But there is, I mean, some councils have strange policies that say that if you're technically homeless but you haven't asked for temporary accommodation or anything, I mean, they shouldn't really word it like that, because it's obviously it's an incentive to people. It's a form of gatekeeping, really, because you're bribing them to not make a homeless application. But be careful what it says, because you may find that you're worse off, because they say, okay, we accept you're homeless, we'll put you in temporary, and that's the end. Then you go down the scale. Shall I move on to Dan then? So thank you for your comments, Dan. And here's the first one. There's a couple of things Dan's put. So this is the first one. So it says, managed to get the council to serve an improvement notice. Thanks to your advice. But now the landlord wants access to the property to assess the work. And the question goes on, is it okay to grant access to the landlord after the section 21 expires, or is it like vampire rules? And oh, you say it's a bit echoey. Is that the sound quality on here?
No, I think potentially not all of us are muted, so I don't. So I think if we're all muted, it should be okay. But maybe one of us wasn't somewhere.
Oh, okay. Because Cheeseface has said lots of echo, Mike. Oh, that's on you.
So yeah, give us a bit. So guys who are listening, you're about 45 seconds behind. Let us know if it's got any better now.
Because you sound fine to me, but then I'm probably not listening to it in the same way. I'll look into that. So hopefully it's bearable. But just to go back, forgive me if I'm being thick or whatever, but what is vampire rules? Is that some
I don't know.
cultural
cool,
thing I've missed out on? Is it from Buffy or something? But sorry, Dan. So what you're saying is, should you not? I mean, should you give access after 21 expires? Well, you could say, what's the point, really? Because if you're going to be going, then you may not want the works carried out. But then, if you do want the works carried out, I guess you've got to give access. I don't think that there's any sort of catch that you'd be worse off if you gave access. What do you think, guys?
So Dan just clarified what vampire rules is.
Oh,
When
right.
you invite them in, you can't get rid of them.
Oh, I'm sorry. Yeah, I should have thought of that. Yeah.
So I mean, I think ultimately, I think what you want to be doing is just making sure your situation's covered. So making sure applications being made with the council. So section 21's been served. It's now. Does it say it's expired? Have I read that right? Yeah. So after the section 21 expires. So really, I would say you're at that point. In my opinion, your landlord's not your priority. It's about making sure the council accepts the duty they should accept, getting that process all up and running. But equally, I would say don't be difficult. Like I don't. Yeah, I don't. I mean, yeah, I think the danger, I guess, is the landlord just says, well, I don't care about this tenant anymore, so I'm going to do all the works whilst they're still living there and make it unpleasant. So I'd say I don't know what there is to lose by kind of being uncooperative with the landlord at this point, but I guess it just, you kind of play it by ear. And I think if you set out very clear arrangements with the landlord in writing about when the work's going to get done and what's going to happen, what's it going to look like, you probably safeguard yourself against that. Like, I don't know there's any cost to being seen to be uncooperative at this stage, but you know, why be uncooperative if you don't have to be, I guess. So I think I think you just want to get clarity from the landlord what the work's going to be involved and how kind of invasive it's going to be. Probably that's my answer. I don't know what else you could think of at this point.
I remember, I just had a flashback to, there was a TV series in the early 90s about, I've forgotten what it was called, but it was about a solicitor, and it managed to make his life a lot more glamorous looking than most solicitors. But believe it or not, in one of the episodes, he was instructed to try and evict some squatters from a property. So what he did was dressed up as a builder or from the council and said there was a gas leak in the property, went in there and got the people out into the street while he was doing the work with his sort of council gear on, and then changed all the locks, and then they couldn't get back in. So maybe the reason I've had that flashback is I think maybe that's what Dan may be alluding to when you say, is it okay to grant access? Because they can say, oh, you've got an expired section 21, so while we're here we may as well evict you, and we're not leaving. And if you nip out to the shops while they're there, you come back and find the locks changed. But that would be unlawful eviction, because the tenancy doesn't end until a possession order is made, or in fact even enforced by the bailiff's warrant. So they wouldn't be allowed to do that. I hope that answers that question. I think there was Dan had another question. No, that was the
So Dan just put an extra comment there, just saying, I think he could appeal the improvement notice if I was obstructive. So I guess, you know, just don't be obstructive if that's something. I don't know. I'm not familiar with this kind of these.
I think you probably could actually, yeah. But I'm not an expert on improvement notices. But I mean, it would make it difficult to enforce it. He'd have quite a good defence to say, well, I've been trying to comply, but the tenant won't let me in. So if I go back, unless you've got anything more to add, anything more, Dan, on that one, I'm going to go. Cheeseface has put a comment on here, or a question, I think. Person X today received a copy of the referral letter. Oh, this is our one we're familiar with here. So person X today received a copy of the referral letter from TH to WF. TH are using section 213 to help them discharge a function under part 7 due to the exceptional circumstances of person X's case. Now, can anyone, there's a prize for anyone who can say what 213 is. I'll just see if I can.
It's the kind of, I don't think there's any teeth in it. So it's basically the duty to, well, it's not duty, it's kind of the ability for one local authority to call on another's help.
Oh, yes, that
one. You can imagine how well that's going to be received by Waltham Forest. So I don't, I'm just reading through the actual detail of it now, but there's nothing I can see in there which basically means Waltham Forest have to comply with Tower Hamlets' request.
Yeah.
So you know, it's not going to do any harm, but I mean, call me a cynic. I don't know that it's going to result in kind of anything useful. That would be my sort of first impression on that. I've not seen it being used. I've certainly seen when councils argue with each other and it doesn't really go anywhere. And really what happens in those arguments is you figure out which of them has a duty to do something, which I think, going back to this case, it's Tower Hamlets. They're the ones who I think have the duty rather than Waltham Forest. And so Waltham Forest can basically stick their fingers up at Tower Hamlets and say we're not helping. Or if they do help, there'll be some sort of payment or some sort of like reciprocal arrangement or something. They're not going to do it for free. That's, I think, the kind of would be my. But we talked before about reciprocal arrangements. So actually, I guess, you know, it might be a prelude to actually getting a reciprocal arrangement going on and actually Waltham Forest doing that. So I don't know. So it's not. It probably sounds like progress. I'd be very interested to see what happens. I guess is probably my not very helpful answer.
Yeah, me too. I mean, I don't think they need. I mean, it's a long time since I looked at section 213. But as far as far as I can see, if I remember rightly, forgive me, I've forgotten. It was Tower Hamlets that placed the person in Waltham Forest, and the person's trying to get back into Tower Hamlets. Is that
No,
no,
so
the other way around?
they want to be housed in Waltham Forest. I mean, correct me if I'm wrong for the person, but they want to be housed in Waltham Forest. They've been there for like 14 years or something, which predates the Localism Act. I think that's what's happened. And so Tower Hamlets has got the duty to provide the accommodation, but they're saying they
Yeah.
can't possibly be housed in Tower Hamlets. So, which is nonsense as well. So Tower Hamlets can absolutely secure accommodation for someone outside their district if they want to. But I think this person quite rightly wants to see if they can get Part 6 accommodation, which is absolutely sensible. So
From Tower Hamlets.
yeah, from Tower Hamlets, but in Waltham Forest. So as in like there are councils can do it. They just only do it if they're motivated. So I'm just reading the second part of the question. So
Oh, sorry.
Found out that the council can offer accommodation in another area under Part 6. Is person X shooting themselves in the foot with a referral instead of asking for a Part 6 final offer in Waltham Forest? So, I mean, again, I've not seen the situation, but I think this is a sensible question. I would almost because if you want social housing, then it would be more logical to request a Part 6 final offer in Waltham Forest before you kind of go for the referral. But again, to be honest, I've not seen these in practice, so I don't know.
I've never heard of this.
Yeah, I mean, so it's again, I think it comes down. I think the only way that Tower Hamlets can source social housing in Waltham Forest will be it will be with the say-so of Waltham Forest. And I don't know, unless there's some kind of way of getting into social housing, with the housing association or something. So I don't know, but I think I would say it would be sensible to wait to see what happens with the Section 213. As I say, it might just be a prelude to actually getting a reciprocal arrangement, which happy days, where Tower Hamlets would take someone into social housing from Waltham Forest, and Waltham Forest would in effect get this person onto the housing register in their area. That's my guess, but I don't know for sure. So yeah, that's about as helpful as I can be. I think just wait a little bit of time just to see what happens. I think it seems like there's movement, because I think last time we kind of heard from the situation, nothing was really working. They were just ignoring. Tower Hamlets were just ignoring everything. Waltham Forest were telling her that it was all Tower Hamlets' job, so they weren't getting involved. So yeah, I think that's kind of.
So I think
what's happening.
What we'd have to ask Cheeseface, if you could do, is let us know. You've seen the referral letter, so the next step is to see the response to the referral letter, and let us know what that is, and then we can see what the legal implications of that are. I think that's all the questions that we've got, the comments that we got so far. So I'm not. What I was going to say is that I spent an hour, just over an hour, listening, and I've done it. Actually, I've revisited it, listening to your video, Mike, on. And I say listen to it because mostly I was out for a long walk, and I listened to it while I was walking, because you don't actually need the visual for it, so that it's like a podcast really. But the one on how to make a complaint, and I was thinking, I don't know if people would like this as a format, but I mean, you just to remind me again, how long does it take you to make a video that long? Because it's very, I mean, it's. I'm thinking when I watch it, I think, God, I'm so lazy.
It takes ages. So because basically you've got some videos you can just kind of do off the top of your head because they're just a live question. So like one of these questions you've got tonight, you kind of just do it freestyle. But that video, I kind of spent some time just planning through what things I wanted to cover, what order to put them in. Then recording it, I tend to take a couple of times to actually get it right. Then I don't know how long the video is, like an hour long, I think. So
yeah, it was just over an hour.
You then have to go through it again and edit out all the ums and all that sort of pauses, and sometimes I mess up, all that sort of thing. And then so it feels like it takes a day to get a video like that out, probably in total. I mean, you can do it quicker, but it just depends how fluent you're feeling, basically. So some days I kind of it comes off the tip of my tongue, and other times it doesn't. So it kind of felt like it was a lot of useful information that I would have liked to
Well,
know.
yeah, and I think
10 years ago, really. So
I was thinking one thing we could do with these live streams, if we don't just spend our time responding to comments and questions, which I mean are always welcome, but we could actually use those as a springboard for discussion. Because the thing is, you've done so many really good videos out there, but it's like with people, solicitors, we tend to go on courses and we go on a course for a sort of half a day and listen to some really good stuff and think, wow, I feel really good. I'll put the materials down, and then a year later you find them where you left them, and you think, how could you make this more dynamic, as a sort of living thing? And I think what I'd like to do, and I was thinking, should I do a reaction video to Mike's video, where I'm sort of saying, I like this bit or that bit. And then I thought maybe we could have a discussion about it. But I think maybe the best way to do it would be to have questions. We could have a live stream session, and everybody would have to do their homework in order to benefit from it and watch the original video. And then we could have a question session. Like my son had a question. He said to ask you, because he was listening in the car to the last bit, and you were talking about the time when you went to the council's offices and you went back after being told to wait for them to make a decision, and the senior manager was in there and read you the bit about the section about fraud. And you mentioned in passing, you said there was also a dodgy housing officer involved in this scenario. My son said, "Oh, please find out what was the dodgy housing officer? What was dodgy about him or her?" I mean, if
Yeah,
you can say, I mean, you don't.
yeah, no, I can. I mean, I can. So I've got no problem saying it. So, up and so there was. So when I worked in the housing team, there was a number of dodgy people. She was one who just overtly gatekept someone because they're travellers. Like, no, didn't even ask their name. Just like, you're travellers, you know, go somewhere else. So there's one of the things I whistle blew about. But then in the first, up from the point we formed Just Us up to the point where she left the council, like 3 or 4 years later, she was involved in over half of the upheld complaints, the really serious complaints. So her name was in it somewhere. So in that case, so although we saw the new housing officer at the desk and the big manager guy, this other housing officer was in one of the private interview rooms, and I saw them go and consult her, and I saw her laughing about some stuff, and I thought, you're just vile. And then they came back and said, yeah, we do a same day non-priority decision. So she was in effect the most experienced officer out of the three in terms of homelessness decisions. And was, yeah, I think essentially was the one that kind of pushed for the same day non-priority decision. So, and she still works. She works in the domestic abuse organisation now, which I just, given that most of the serious complaints were domestic abuse cases, I shudder to think like just what she's doing or what she's saying, because she was actively preventing people from getting the assistance they were owed. So yeah, one of the worst ones. I've said elsewhere, some housing officers were fine, but she was one of the ones who would say she was very nice, but actually did a lot of harm, in my opinion, to a lot of people. So yeah, I don't know if that answers your son's question, but
It does.
It's all that sort of stuff that happened, really. So
yes. And I thought other questions I'd like to. What I'd really like to do is try and have a discussion where we could talk about legal. It's not a sort of one versus the other, but it's how you combine the two. Like the complaints process, we can. It's a bit like, you know, when you do a sort of price. If you look at a piece of software and there's the pricing table between the premium, the free version, the premium version, and the really expensive, and there's ticks down the side, and you get everything. And I was thinking with complaints is much better in a lot of ways, except the box that it doesn't tick is gets the solution fairly quickly. But then I thought, well, that's only because I'm used to thinking about the ombudsman and then a sort of a 28 days for a stage one. But then I thought, well, actually, if you do this like you were describing, and you include councillors and the chief exec and maybe media and stuff or whatever, or people that would actually be making a nuisance of themselves to the team rather than just going through the complaints procedure, it could actually be pretty fast. I mean, so my question there would be, do you find that there are ways you can sort of expedite it, or do you have to sort of sit back and say to the person, sorry, you know, this is like, you may get some justice at the end of this, but it's not going to, you may be sleeping rough for a bit?
yeah, so I can't think of a case off the top of my head where we weren't able to get them housed long before the complaint was upheld. So yeah, I'm just thinking if there are any exceptions to that. So in almost so we would just escalate it and escalate it and escalate it. So if we got the wrong answer from like one manager, we'd just go to the chief exec, whatever it would be. We just kind of kept going up, and in a sense, we were only kind of picking cases which were obviously failing. So if it was like a difficult legal argument, then we would try and find a different way of dealing with it. So yeah, I think that's the kind of I cut. So I'm trying to think of the longest time. So that the lady, the case I mentioned in that complaints video, he was homeless for like I think from between a Tuesday and a Friday, she was without accommodation when they were very clearly a duty to house her. But that was a case of making a fresh application with information I was able to get from the GP. And then the complaint happened. The complaint was probably resolved 6 months later, but by then she was already housed.
So this is the same case where they've done the instant priority need, or non-priority need.
Yeah,
and
I'm thinking. Sorry, I was just thinking a case in Luton. I mentioned it quite a lot because it was the worst case I ever saw. But that didn't result in him getting housed. We got him housed by a different council, although we did get £500 compensation for a same-day non-priority decision, but it took 10 months to get the compensation. But by then, we'd already gone back to Bedford by then and kind of got him housed elsewhere. So, yeah, so it didn't work in Luton. So I think that's probably the only situation I can remember where it didn't work. Although I'm pretty sure if we'd have just kind of pursued it, because by this, he was already housed, we got him housed somewhere else like the next day. So if that hadn't happened and he was literally on the streets, then I think we'd just kept escalating with Luton. But they were a particularly bad council at that time. I don't know. I'd be surprised if they'd got any better, to be honest. But that was particularly nasty housing.
Sounds like Bedford was pretty bad before you got involved. I mean, if they were with the percentage of increases of temporary and the routine sort of turning away of people.
Yeah, I think it's probably impossible to know, but I would say Bedford was probably quite average, actually. I think if every council followed the law, suddenly they would all be having a similar kind of increase in their demand on temporary accommodation. Would be my gut. There'll probably be variation between London and whatever, like Northumberland or something. But I think every council I've dealt with, except Aylesbury Vale, broke the law within 5 minutes of dealing with them. And Aylesbury Vale doesn't exist anymore. Every other council, they're gatekeeping almost immediately, like within the first sentence almost sometimes. So I think it's all pretty bad.
Well, we've got to just say hello to Andrew. He said evening all, and evening to you. If it's okay, I'll just go on asking questions and things, and if anyone else wants to stick any questions in the comments, then we can try and answer them. But I've got two questions that arose out of the complaints thing, or generally about, because the video you did before, which if anybody watching hasn't seen it, it's the one about this is not an extreme case. Is it that one, the lady that one of the tragic things, I mean, I would say to people, one of the best legal textbooks to read is The Trial by Franz Kafka, because it sort of shows that however horrible I mean, it's just a load of word salad that people get, which is really sinister, and you don't know what's going on, and that's what the law is like. And the other one is, well, obviously 1984, or and there's a sort of Orwellian Kafkaesque inevitability about local authorities, which is that you think, oh no, they couldn't do that, and then they not only did that, but they did it even worse than you thought. Like that woman in the extreme video doesn't just get told once, we'll take your children into care. She gets told it by like 2 or 3 different authorities, and that's their response to requests for support from children's services. Now, if somebody asked me to write a script and I wrote that, or somebody'd written a script about that, I would have said, I think you're exaggerating a bit. I wouldn't, but it really does. But I don't know I mean, I wish I sometimes had time to study this and maybe do some writing on the psychology of bureaucracy, because it seems to gravitate to the point where I think people are just so, they get gravitated to being cruel to each other, or just not doing what they're supposed to do. I don't know. Do you think that's something we have to sort of just factor in, that if you say to people that you've got a statutory duty to do this, this, and this, then you can guarantee they'll turn it on its head and do something really terrible?
Yeah, I mean, so I think I don't know, like my experience. I know Karis, you probably got some opinions on this as well. But so I think my experience of talking to housing officers, it's amazing. They think they're the victim, like consistently. That's the sort of thing, when you talk about what they, when they talk about what they do, and I talk about gatekeeping, and they sort of say, oh, you don't know how hard it is, and they genuinely think like they're the ones who've got it hard. They just seem to lose sight of the fact that no matter how bad it is, they can always go off sick, whereas the person they just left homeless can't. They're stuck. So I think there's that kind of they just genuinely get themselves into a place where they don't see any agency in what they can do. They see it as inevitable. They see what they're doing as the greater good. They see what they're doing is about protecting local authority resources and making sure the most vulnerable people get them. But in reality, that's not what happens. They end up kind of tending to be nice to the most nice clients. Almost the ones who are most middle class and kind of cry in the customer service centre and that sort of thing. Sure, I'm not saying they shouldn't cry about it. It's just big, but almost like the hardened guys and girls who have kind of been through it already and just kind of like seem like they're taking it in their strides. They're the ones who kind of end up with nothing. So I remember a guy went in with them. I was actually surprised they found him in private without me arguing with them, because he was visibly shaking within the interview. And I think it was because he was visibly shaking, they thought, oh, this is real. But actually, I've met people who've been through much more difficult things than he'd been in that run-up to what happened there. And they're so kind of disassociated, or whatever, they just have this poker face where it doesn't seem obvious that they've actually gone through a huge amount of stuff that they have. And they're the easiest ones to gatekeep. So yeah, that's my bit of my answer there. I mean, I'm planning a video which is why do housing officers break the law so much, and I want to talk about these kind of things. So, but it's I think Milgram, his agentic state kind of theory is really helpful.
Yeah, I was
I
looking
also
that
think
up.
Hannah Arendt's stuff on the banality of evil is really helpful as well. So without kind of mentioning the elephant in the room, like she talks about how the people who do terrible things in civilized countries, they kind of think they think that they are somehow having to do it for the greater good, and they don't like doing it, and it's almost like a sacrifice. These people have got harm is like a sacrifice, when in the reality is they don't have to resist at all. Hannah Arendt talks a lot about how even entire countries in Second World War refused to cooperate with the Nazis, and there was no repercussions. So like Denmark said, no, we're not gonna kind of deport any Jews to you, and there was actually no repercussion for it. And the Germans who were doing the bad stuff, if they said I don't want to do this, they wouldn't get any shit for it. They just get taken off duty. So there's a couple of important books. One is called by Victims, Bystanders, Perpetrators, I think, and then there's another one called what's it called? It's like unit. It's like the name of the unit of the people doing it, and it just kind of goes into that psychology. I've forgotten its name now, but I've got it on my bookshelf somewhere. But I would say a lot of that stuff is quite instructive for understanding why housing officers get up in the morning, don't intend to do any harm, but by the time 5 o'clock comes along, they've actually done quite a lot in a measurable way, really.
Yeah.
And they still are the victim. So yeah,
And that's
not sure how helpful that stuff is, but yeah.
I think we'd have to do. We were talking a while ago about doing a thing that is not sort of topical now, but I think it will be, because the inquiry's coming back to life in the autumn. But the post office inquiry, to me, was revealing. There's a saying in criminal law amongst criminal lawyers that you get the same client every week, but just with a different face and name. And with the people that were on sort of being questioned at the post office inquiry, I recognised so many people from housing law who happened to just be working in the post office instead. But there was the sort of middle management person who doesn't give a monkeys and is rather angry at being questioned, up to the sort of very sincere, smooth talking top manager who has failed to acknowledge terrible things happening, and thinks that they confuse the council, the interest of the council, with the interests of the council, what the council's supposed to be doing. So so many things that I thought it'd be good to talk about. I don't know quite how we learn. I mean, I think the thing you learn is that you just have to assume. And whenever I'm talking to people, I just have to be talking to clients, I have to be so negative, and to say, well, I reckon this and this and this is going to happen. And they say, oh no, that sounds terrible. And I say, well, as long as I'm planning for that, if I said, "Oh, don't worry, I'm sure once they've got my letter, they'll give you temporary accommodation and they'll all be nice about it," I said, "I've got to threaten them to do this and this, and then it works." I say you only get nice surprises after this bit, but it's sad to have to give that advice, and so yeah, there's lots of inevitabilities on that. So I don't think there's any more questions there. And we're going to do, Mike, we're talking about doing a session on suitability. As I mentioned, I think at the end of on your show last week, I just had a case on suitability, and I've prepared some notes because the barristers do this thing in a homelessness appeal. You get the barristers the day before the hearing, or as part of the hearing process, they're supposed to put in what's called a skeleton argument. And the skeleton argument is quite a useful document. It basically, as you probably imagine, it sets out the facts of the case, the law, and the submissions that barrister makes as to why they should win or lose the case. So each barrister will probably mention at least some of the same cases. And so I was going through our arguments on affordability. There's quite interesting things to talk about there. So we'll try and have a session on that. What I'll try and do is prepare, because this is I'm waffling a bit today, but I will try and prepare some notes and things we could go through that if we've got time on a future live stream, just to talk about. Because it was interesting. One of the things that we were raising in the appeal was the issue of bias, and this goes back to what I was just saying a minute ago, because we were saying that by the time they did the second Section 202 review on this case, they were just biased, and they would just look not in the sense that they sort of hated the applicant or something, but they were just looking to justify their earlier decision, which is not the same as carrying out a fair review. And there is a case on bias which I'm going to read up on, but the judge said, "Oh, I don't think you can call it bias." But I thought, well, it's crazy. But it's a bit like a stage one complaint, that a Section 202 review is always going to be biased, because it's like if I said to a member of your families, "Could you, I want to make a complaint about these guys," they're bound to be biased and want to stick up for you, and so that sounds really interesting. But it's a strange mismatch, because the judges would say, "Oh no, they can't be biased," but the whole reviewing officer function is as I see it. I mean, they're part of the same organisation, so they will inevitably be biased, if only subconsciously. So that was interesting.
So what? I mean, I don't know how much you can say in terms of give your opinion here, but like, surely judges know what the game is, right? They must surely know what's really happening in these cases, or are they just that naive that they're? I know you've got to be careful what you say, but I can't believe like a judge who has read various cases involving, let's say, now medical or housing reviews or something, doesn't realise that something's rather kind of and I think I can even think of a case where there was an argument to say housing reviews are biased, and the judge came back and said, well, no more biased than the council would be. So I was like, well, you must know something's off here with this stuff, but I don't know. Do they not? Are they kind of naive about what sorts of things happen in frontline housing option services, or are they kind of just apathetic about it, or something
I
else?
think a bit of all of those things. Plus, they have to maintain the sort of role. I mean, it is all a bit theatrical. So a judge has to sort of pretend to be some sort of not a Bertie Wooster type, but some sort of innocent, sort of middle class character that doesn't understand the ways of the world, and that way they can be unbiased themselves. If you see what I mean. But then again, say the judge on my case last week. I mean, she is a very experienced barrister who's a specialist in housing law, and she used to mainly act for applicants, so she knows exactly what's going on. But she's the one who said, "Oh no, you can't say they're being biased." But if she was talking to us in private, she would say yes. And I think, to be fair to her, I'm not saying that she's sort of a fake person, but I mean, as a judge, you have to sort of step back from it and say, well, I'm not just going to join in we're not all here just to rant about injustice. You've got to show me that they're biased, and it is difficult to point at that. Although an example was that the judge, I mean, the review, hang on, the barrister for the council said that we pointed out that in the review decision letter, they said we remain of the view that blah de blah. And so we said, well, oh, that's just them confirming their existing view. And the barrister said, no, they're not saying we remain of the view because it's a long-standing thing. It's because they've just considered our representations at the review stage. But then we pointed out that the Minded To letter, which they'd sent way back, said exactly the same thing. So they were, they were biased. I mean, I think people are biased, but you just have to build it in. But I think a lot of judges aren't specialists in housing, but they must know from local authorities just dealing with homelessness cases that that's happened. So occasionally they really let rip and get angry with councils. But it's sad that it's a sort of you're slightly working in an unreality where they won't sort of roll their sleeves up and accept what's going on the ground. I've got a question from Dan here. Sorry to ignore you for quite a long time. I'll put that in. Oh, not a question. Oh, am I allowed to do this? Because Dan, you shouldn't really say your landlord. Somebody you know's landlord, maybe. I'm going to take you out of there. I'll just say that a landlord has notified somebody of a rent increase of 80% the exact same day he was so he was served with an improvement notice by the council, even though the property is still not in a marketable condition. Yeah, this is a problem. This is sort of, I mean, the question there really is, what can you do if you manage to dodge the repercussion of complaining about disrepair, of getting a Section 21 notice and being evicted? Then you've got the other problem, which is that if the landlord does the work, then the landlord's going to say, "Well, I'm going to charge you 80%," which in a 80% more, which in a way is the same as serving a Section 21 because you can't afford to stay there. And I had this problem the other day. Somebody asked me for advice about a tenancy which began in 1991, and back in 1991. If you wanted to create an assured short-hold tenancy, you had to serve a notice that it was an assured short-hold tenancy. Whereas maybe one of you two can tell me the exact year, I can't remember, but it changed later on the other way around, so that in order not to be an assured short-hold tenancy, you have to serve a notice that it isn't an assured short-hold tenancy now. And so anyway, she hadn't had any work done for years. So it wasn't in a terrible state, but the landlords wanted to carry out repair works. And she was asking me whether the agreement they'd got for decanting her somewhere else was dodgy or not. And I was saying, no, it isn't. But the big worry you've got here is that it was in Cambridge, which is the centre of Cambridge. So, I mean, it's really expensive rents. I said, I'm sure they were going to put the rent up, but there's not much you can do because you can't say, no, I'm not going to let you in to do repair works, because they could ultimately get an order, but you're stuck there. So, I mean, I agree, Dan. It's not really a question; it's an observation that the landlords, or you're telling us the landlord's done that. But it's something I guess they're going to do, because they're going to think to themselves, "I've got an improvement notice, so I've got to basically pay for all this repair work. What am I going to do? Oh, I know. I'll charge more rent, and plus I can get away with it." And it shows the unfairness and perhaps the unsuitability of the private market for renting, because it's crazy that getting your home put into a decent condition means that you could lose your home, put yourself at risk of losing your home.
It's something we're raising with Bedford Borough Council, and the way we're approaching it with Bedford is we're asking council what steps they can take, because you see a landlord like that, you're like, this landlord's dodgy. There's no two ways about it. They've kind of got these big disrepair issues. They've been, they need to serve an improvement notice. The question we're going to put to Bedford is what legal powers does a council have to deal with a landlord like that? At what point does a landlord stop being a fit and proper person? And my guess is actually in this situation, it's probably going to say, well, this isn't technically, the landlord's not technically doing anything wrong. But we can kind of see it stinks. We saw that MP from Ilford, like with his 15 properties and all that sort of stuff. And you're like, I'm sure that he's going to come up with some excuses for it all, but any layperson knows that that guy is, just proper hypocrite, if nothing else, really. And there's just a lot of them, I guess, a lot of landlords like that. So
Yeah, I mean, I suppose the only way to do this is that there'd have to be a moratorium on people being able to take possession action where for a certain amount of time, because ultimately, if this guy puts the rent up, then and it becomes unaffordable, then there's going to be possession proceedings at some point based on rent arrears. And if you said, well, you can't rely on rent arrears as a ground where this has happened for say 2 years or 3 years or something, that would at least give some protection. Because I suppose you can't say he can never put the landlord can never put the rent up. But there's another bit to the question, which I shall put up, if that's okay. Is it reasonable to limit access to the workmen if they're going to cause a big disruption? Only allow one at a time, etc. What do you think, guys?
well, as a workman in my other job, like, I'd be annoyed. I think you probably you bet, if, in one sense, it'd be less disruptive if you can allow. I mean, I'm not quite sure what work's involved here, but to allow the kind of workmen in to do it in a shorter time, otherwise you're basically stringing it out. So I mean, it sounds like there's some. I can't remember exactly what the issues were, but it sounds like there was potentially some structural stuff. Was this the one with the acro prop in the bathroom or something like that? I can't remember if it was that one, but that's. You want to get that sorted sooner rather than later, and I think allowing one workman in is just it's probably just not practicable. So I would say have the conversation with the landlord in writing to kind of establish what the timeline is, how long they're going to take, when they need access, all that sort of stuff, and just, I guess, try and find a way of working around it all, really. I mean, I guess the question to ask the landlord is, why don't you just wait until I'm out? Because that won't necessarily be that far away. And actually, workmen will be able to work more quickly at that point because they can just spread out and just kind of do what they need to do rather than having to worry about having an occupant in there. So I don't know. I would say you want to be more. I would say once you're sure the landlord's not going to legally evict you, is to be as cooperative as possible, and just allow the workmen access as soon as they need it, really, for as long as they need it, and be prepared for workmen just being workmen and getting dust everywhere and delaying and drinking coffee all day and that sort of thing.
Having said that, I would say that it depends how big the disruption is, really, because if they've got to carry out sort of major works that are going to create, like you say, dust and sort of rubble, and that's going to go on for weeks, and you've got kids living in a place, and all of the rooms, I'm just going for an extreme scenario example, all the rooms are affected, you would be entitled to say, well, you've got to provide me with alternative accommodation, or wait until I've been able to find that. I mean, it's always a difficult thing with private landlords because they're not under an obligation to decant you, whereas local authorities and big landlords are more likely to do that. But I've been dealing with a case recently with Lambeth Council where they did decant someone, but guess what? They put them in somewhere that was just as bad. There was still damp and water dripping through it. So the problem is she wants to get the works done extra fast because she wants to get out of the place they put her in to decant her. But in this type of case, I wouldn't say it would be unreasonable to stop access at one. I mean, reasonable is always, say, a lawyer's favourite word because it's sort of completely elastic and means whatever the lawyer tries to argue it does. But if it's just if you're just sort of having a feud with the landlord because you don't like each other, then bear in mind that they could take you to court and get an order requiring you to give access, and you could get ordered to pay their legal costs, and it makes it difficult for you to claim compensation. So I mean, it's reasonable to deny access if they're going to cause an unreasonable amount of disruption, I suppose, which is a bit open-ended.
If they're
if they affect your health, sorry, and if they affect your health, and the health of your children, isn't it?
I think so. Yeah. I mean, that would be good examples of where it would be an intolerable disruption. Whereas if it's just that there's sort of somebody coming to the house in the mornings,
I mean, if they're plastering, it's going to get messy. I mean, if they're plastering significant amounts of walls, they're most likely going to rip the carpets up first if they're sensible, and then kind of, depending how many walls and ceilings need doing, then it's going to be very disruptive. I mean, just comment there saying the landlord seems to be trying to harass. I mean, so yeah, I wouldn't be surprised if that was the case at all.
It will be, although I find that but the problem with disrepair is, and no disrespect to you, Dan, I'm not suggesting you're doing this, but by the time things reach a certain point where the landlord and the tenant are so fed up with each other that they can't figure out what is reasonable. And I get copied into. I mean, at the moment, I've had this dispute going on, and I'm copied into the emails between the landlord and the tenant, and it's difficult for them to agree on anything because the tenant, often tenants get to the point where their only feeling of getting their own back is to be as difficult as possible and to say, oh no, you can't come round, you can only come round to do the repair works between sort of 2 and 5 on a Saturday afternoon. So be careful, because it can go both ways. I think landlords will try and harass, but often the landlords do genuinely want to get the, I mean, I sound like I'm apologising, but they will genuinely want to get the works done, and they're presumably having to pay builders, so using builders as a form of harassment. I mean, I'm sure it happens a lot, but it will often seem like they're trying to harass as well, especially when it's done in bad faith and it's coupled with sort of accusations of it's all your fault, you've been sort of cooking with the windows closed and stuff, and that's why there's mold all over the flat. So yeah.
This is going to seem like a really kind of off the wall tangent, but there's one of my favorite programs is an American show called Impractical Jokers, and it's like these improv kind of troupe who just put themselves in ridiculous situations, and they're not playing jokes in public, just kind of, they've just been very awkward kind of situations, and it's really interesting watching them basically respond to the way that people react to them. It's just kind of, for me, it really illustrates just how it's not actually difficult to be very unpleasant to someone just by the way you're being with them, your demeanour, that sort of thing. So you don't actually have to say anything particularly nasty to actually be quite threatening and quite unpleasant and create a real atmosphere. And so I think landlords have, you don't have to be there. Landlords don't have to be coming like waving a stick at you or something to make you feel threatened. It can just be kind of just a tone and the kind of, a few like little ambiguous comments here and there that can actually ruin your day. You just kind of, they have control over your home and can make you feel very uncomfortable in those situations.
Definitely. I think there's a lot of psychology in there, isn't there? Because there's the sort of primal thing that it is somebody's home, and if a landlord is unsympathetic to things in the home or behaves in an intrusive way, we really are sort of dealing with a part of the brain that is like bears or something like that. That if they get angry if somebody goes in their cave, and if you're protecting your young or something, and you've got some landlord who's exposed your children to mold, it's a very thin line they've got to cross to piss you off really badly. And similarly, the danger then is that tenants get so angry with the landlords. But I mean, it's. I spend a lot of time.
It's quite an imbalance of power, though. If someone doesn't know what their rights are and they're stuck in a position with, and then they read everything on the internet, but then this man has to actually, or this landlord, it might be a lady, comes around and they come into your home, and it's like that imbalance of power. They've got to then work out that relationship again. They're suddenly in your house and they're not someone on the other end of the phone or down the email. When you've read all this stuff probably online saying, well, they can't do this and you have rights, but what are they in practice? And how do you enforce them if you don't know them? I don't know where to look.
So one of the things that was in that video I put up with Leonie kind of talking about her situation, that she made that point. She said all the landlords she's had have been men, and they've all got into her personal space and kind of squared up to her and stuff like that. And maybe you see from the video, she's quite, I don't know, quite, probably have a go at someone back sort of thing. She's not kind of a, what's the word, kind of a wilting rose or whatever the saying is. She's somebody who can hold her ground. But she said actually consistently the landlord she's dealt with would use that kind of that kind of power imbalance to make the women feel very, very uncomfortable. And another thing I remember someone else saying that her experience of some landlords in London where they all would be just really creepy and kind of sexually harass her and stuff like that. She's quite a young female at the time, and just saying how there was that kind of whole sort of thing going on as well. So it's I think that kind of sort of aspect of this stuff isn't probably talked about very much, but probably is actually quite significant for a lot of people. So, it makes me think kind of actually finding out more.
And most workmen are men, and they come round. If they come round in a group, you've then got the lone female with their children, and it's like, well, they've all come round. There's no delicate way. And it is quite a bad saying if they're intimidating, but if you're a lone female and a group of men come round while they're doing something else, it's like we've had complaints of workmen where they've forcibly opened the door and said, well, we have to do this and we have to get it done. It's like you have no right to force the door open. So it's quite bad, because also they're trying to do the work that they're paid to do. They've got a job list to do. They're on to the next one. But you've got to fit it in with making everybody comfortable, especially if you're going into someone's home.
Yeah.
And there is builders, so you can complain about builders separately.
It's an interesting thing you're saying, Karis, in terms of it's one thing to have the right, to know your rights, but then it's quite. I was always quite struck by the difference, or what landlords were knowingly allowed to get away with by councils. So councils, would kind of have a safeguarding alert come in saying, there's evidence saying that this landlord is exploiting this particular tenant, and really the council's response was so just, it was nothing basically. It was vanilla, just kind of like, oh, we'll give the landlord a phone call. It's like, the allegations here are really serious, and that's all you're going to do. And I think it partly comes down to, again, they don't feel like they can annoy landlords because they rely on them. So yeah, difficult situation.
So I think, unless anyone else has got any questions, I think we're moving towards the end. And thank you both for sticking with me and getting through this one. I'm learning these things will get more, will get better. Because I think we'll just draw up an agenda. I'll draw up an agenda and things to talk about. I mean, it's been very useful and interesting for me talking about the things we talked about. Is there anything, Karis, you maybe have a think if there's anything you'd like to add to, or have discussed at future discussions or during live streams, if you feel, because if it's us two talking over you.
It's brilliant to just have that sort of ping pong with, you guys. It's really great to listen to. But I would love to see, and I emailed about you doing a video on the requesting the housing information request. I think that's really good, and that
Subject
sort
access
of
requests.
coincides with, and that coincides with your complaint, because you talk about getting the housing file, but whereas I'd say under this legislation you're allowed and put in the section of the Housing Act and the data protection, but you just said you can request it. So it's quite interesting where that aspect's come from. You can put in the legal bits there and say, actually interject this, and you'll get a bit further, maybe.
Yeah, I mean, maybe we talk about it next time. I mean, I think so. I've never asked a council officer for the housing file as such. I've just done the full subject access request to get everything, because I'm just suspicious that they won't give you the stuff you actually need. So yeah, maybe kind of roll that
let's
into next week.
Do you often get the question, which documents do you want?
Yeah.
You say, well,
I'd never get that. They just don't send it all.
Well, I don't actually know yet because I haven't got them. But okay, well, thank you very much for joining me, and hopefully we'll be back on again next Monday, and we'll be back Thursday, on your show, on your channel, and
cool.
I think the format's going to get better each week on here, honest, and thanks for bearing with me while I learn it. So that's all for tonight then. Enjoy the rest of the evening, everybody. Bye-bye.
See you later, guys.